I see a lot of people submit their own green card applications to become permanent residents. And one of the reasons I actually started this channel was to provide information to help people improve the chances of successfully submitting their own green card applications. Or if they need an attorney to do it for them, to provide a resource and to help you make that decision more easily. So there are 3 mistakes I've seen people making on the most recent edition of the green card application, which just came out very recently. So I'm gonna quickly get into it. So there are 3 specific questions that I think people need to better understand when they're filling out the green card application. Because the environment that we are in right now will empower USCIS officers to deny green card applications for minor technicalities or, more seriously, for fraud or misrepresentation. So I've talked about some of these things in other videos, but I know there are a lot of new viewers, so I'm gonna quickly touch on those and I'm gonna get to the 3rd point, the 3rd mistake that people make, which is new and unique to this video. So the first 2 mistakes that people make are with questions 12 and 13, which you can find about midway through the green card application when you reach the long laundry list of yes or no questions. So questions 12 and 13 basically say, have you ever worked in the US without authorization? Yes or no? Have you ever violated the terms or conditions of your non-immigrant visa? Yes or no? Let's start with the non-immigrant visa one first. So if you've overstayed your tourist visa or your student visa and now you're married to a US citizen, then you've probably violated the terms or conditions of your non-immigrant visa. First of all, overstaying is a violation of the terms. But also, even if you haven't overstayed, there is a strong argument that the moment you formed the intention to permanently live in the US, which you clearly have if you're submitting Form I-485, an application to permanently live in the US, permanent residence, then there is an argument that you should always answer yes to that question because you've at least overstayed. But even if you haven't overstayed, you probably have changed your intent, and that new intent to permanently live here is inconsistent with the non-immigrant intent that's required for a tourist visa or student visa. Now, one caveat I wanna say, and this video, by the way, just before anyone makes a mistake that could really impact their status in the United States, this video pertains only to marriage-based green cards or an immediate relative petition, which does not include all family-based immigration petitions. Marriage to a US citizen is an immediate relative petition, and that's what I'm talking about in this video. So if you've entered multiple times, let's say, as a tourist, and let's say your most recent entry after you entered 90 days passed before you did something to show that you had immigrant intent, like you married a US citizen or you submitted your green card application, the ultimate indicator of immigrant intent is to submit an application saying, hey, I intend to permanently live in the United States. If you've waited 90 days, fine, probably won't be an issue, but just to be safe, talk to an attorney before you submit your own application. But now let's say you've entered multiple times on a tourist visa and not your most recent entry, but the entry before that, you did something to suggest immigrant intent. For example, you worked in violation of your visa, or you told someone, hey, I'm gonna permanently live in the US. The next time I enter the US, it's gonna be my last time entering as a tourist. I want to permanently live here. And that's what you do. So the problem with that is when you re-enter the US, you've now entered with fraudulent intent. So fraudulent intent is a major issue. It means you've committed fraud or misrepresentation, and it could in the future require you to submit a fraud waiver, something you definitely want to avoid. But if you've never previously violated the terms or conditions of your tourist visa or student visa, and your most recent entry was a few months ago, and you haven't done anything in more than 90 days since the date of your entry to suggest that you intend to permanently live here, and then you subsequently change your mind and decide you want to permanently live here, that's okay. And in that situation, I would probably answer yes to that question of have you ever violated the terms or conditions of your non-immigrant visa status? I know that was a little complicated. A lot of people schedule consultations directly with me specifically to discuss that one issue and to create like a strategy and to basically figure out whether they qualify or not. So if you're interested, you could always schedule a consultation directly with me. Now, the other thing is, have you ever worked without authorization in the United States? Same thing applies. If you worked without authorization on prior entries, there's an argument that you were in violation of your tourist visa before your most recent entry, and there may be an argument that you had fraudulent intent at the moment of your most recent entry, which is a huge no-no. You definitely want to avoid fraudulent intent issues. But if you entered the US one time as a tourist, and that was years ago, and you've worked without authorization since then, that's probably not going to be an issue if you're now married to a US citizen. Unauthorized employment by itself, when you are married to a US citizen and applying for adjustment of status through your US citizen spouse, is not going to disqualify you from permanent residence. What will disqualify you from permanent residence is lying on your green card application and saying you've never worked after you've entered the United States. Think about it from an immigration officer's perspective. Let's say you're sitting with an immigration officer at the eventual marriage-based green card interview that you and your spouse will probably attend, and you're telling the immigration officer that you entered as a tourist 3 years ago and you've never worked without authorization. It doesn't seem realistic unless, of course, you haven't worked without authorization. Let's say you've been in school the entire time, or you're a stay-at-home parent, or whatever. If you actually haven't worked without authorization, that's fine. And when I consult with people and I explain this, a lot of people say, yeah, but I've been like a nanny or a babysitter, or I've worked construction off the books. Like, do I really need to include that I've worked without authorization? And the answer is yes. There's nothing to lose by disclosing you've worked without authorization in terms of getting your green card. Your green card will not get denied if you've engaged in unauthorized employment, and that's the only issue on your application if you're married to a US citizen and applying for permanent residence through that US citizen spouse. However, your application can get denied for intentionally lying to an immigration officer. So what's the takeaway here? If you've entered several years ago and since overstaying you've engaged in unauthorized employment and you're now married to a US citizen and applying for your permanent residence through that marriage, indicating that you've engaged in unauthorized employment on your green card application will not by itself get your application denied. However, if you decide you want to lie about it and the immigration officer thinks you're lying, it could lead to a lot of bad outcomes. They could make a fraud determination, which you really want to avoid because then you'll need a fraud waiver and you might not qualify. It's actually quite difficult for normal people in a normal situation to get a fraud waiver. Or the officer might just think that the interview is off and that you guys haven't demonstrated that you're in a good faith marriage. You guys seem really nervous, you're behaving suspiciously, your responses seem to be tailored or very rehearsed, and they might just say that, you know, I suspect fraud in this marriage, and then they'll send you to the fraud unit for a way more intense interrogation of both spouses to make sure that you're in a good faith marriage. If your only issue is that you've engaged in unauthorized employment, my general position is that it's better to disclose it than to try to hide it. And by the way, you shouldn't actually be lying about anything on your green card application, as a side note. Okay, and now the new change that's on the I-485 green card application that wasn't there before, that I think a lot of people should answer yes to. This is question 76. This question basically asks, do you have any unlawful presence in the United States? Yes or no? And then there are subsequent questions that asks if you've ever departed the United States after accumulating unlawful presence. And those questions are tricky because if you answer yes to those, then that means that you've probably triggered an unlawful presence bar and you're ineligible for permanent residence. But to double check that and to make sure you're not eligible for permanent residence, always speak with an immigration attorney before you submit your application. So question 76 asks if you have any unlawful presence in the US, yes or no. And many times when I'm doing a marriage-based green card adjustment of status in the United States, the answer to that question is yes. Actually, out of my last 10 applications, I would say 9 of them, we answered yes to that question. If you've overstayed your tourist visa or you entered as a student and you stopped going to class last semester and you're currently out of status, the answer to that question would then clearly be yes. But what if you're in the US legally on like an H-1B visa, which is a dual intent visa? You could have the intent to not live here permanently or to live here permanently with a dual intent visa. Then in that case, if you're currently working for your H-1B employer and you're fully in compliance, the answer to that question might be no. Answering yes to that question will only matter for preference category family petitions and other green card applications, but not for immediate relatives. And I've done videos on what's the difference between a preference category and an immediate relative. For most adults, there are only 2 categories that are immediate relative categories where you could be out of status. And that is married to a US citizen spouse who's petitioning for you, or when you have a 21-year-old or older US citizen son or daughter who's petitioning for you. Those are the only 2 immediate relative categories. Any other category, whether it's a permanent resident spouse, or a sibling who's a US citizen who's petitioning for you, anything else, if you're out of status, you're ineligible for permanent residence. Anyway, the reason I'm mentioning question 76 is because it's a confusing long question. It's like a paragraph long. And the answer to it for most people who are out of status, well, for everyone who's out of status, is going to be yes. And that's okay if you are becoming a permanent resident through an immediate relative petition. All right, guys, that brings us to the end of this video. The reason I wanted to make this video is because a lot of people are confused about which questions to answer yes or no to on the I-485 green card application. And some people think that if you answer yes to any of those questions, your green card application might get denied. And the answer to that is yes, it can get denied, but those are 3 specific questions that I regularly answer yes to, but there are caveats, and I was hesitant to make a video about this because someone might answer yes to that question and actually end up getting in trouble because they didn't consider all of the caveats. So if you're filling out your own paperwork, you don't want to hire a lawyer to do it, I get it. It's expensive. But if you want to at least consult with somebody to see if you're doing it the right way, if there are any mistakes, anything you can do to improve, you can schedule a consultation directly with me, upload all of your applications to the client portal right before we get started so I can have your applications there and we'll review it. Have all the questions you want to specifically ask already written out and teed up so we can make the best use of the consultation time. And we will go through it and I'll give you the best advice I can to make sure you have the best chances possible of getting your green card application approved. For those of you who are new to my channel, my name is Puyan Darian. I'm an immigration attorney focused entirely on family-based immigration. So I focus on marriage-based green cards, naturalization, and I've been trying to put out a couple videos a week on these topics and all of the policy changes under the Trump administration. If you're interested in these topics, subscribe and I'll see you guys next time for another video.